Good morning, everybody, and it's nice to join you today. Thank you for joining the webinar. My name is Eric Boughman. Thank you very much for that introduction. I'm a founding partner at the law firm of Forster Boughman, and I also run Boughman Mediation. I'm a full-time attorney and mediator, and today I will be giving you an overview of the ethics of AI in legal practice. This is a hot topic. I did a similar subject a month ago for healthcare, for the healthcare practitioners. This one's designed specifically for lawyers. I'm going to try and hit a few angles a little bit differently than maybe what you've already heard and read, and try and attack some tougher issues today. I welcome questions throughout the seminar or after, and my contact information will be available for you. All right, the rules have changed, or have not changed, I should say. They have not changed much. The tools we are using have changed. And the question that every one of us needs to answer is whether we're applying the existing rules to the new tools because the tools are already here. AI is built into your Westlaw subscription. It's built into document review platforms, e-discovery tools, your email, and whether you realize it or not, you're using AI in most of the technology that you're using today and have been for some time. We've progressed from basic machine learning and AI devices that I wrote about 5 or maybe 6 years ago, and when I was a contributing author to the Law of AI published by the ABA back around 2020. And of course, the tools today are much more advanced. Now, the question is whether you're using it competently, ethically, and with appropriate oversight. Now, the rules have not changed that much, and much matters. Here in Florida, we've actually had a few amendments to comments in Rules 4-1.1 and 4-5.3 to specifically reference generative artificial intelligence. There's been some movement, but the core duties, the framework, those are the same duties that we've always had as lawyers. Competence, communication, confidentiality, reasonable fees, and supervision of non-lawyers are existing duties that we've had and will continue to have. What's new is the technology that we apply to them. Now, before we get into the rules, I want to show you some examples of what happens when things go wrong. This is not a theoretical discussion. On your screen, you will see a chart showing actual sanctions cases from 2023 through 2026. And I want you to take a look at the progression. 2023, now famous case involving Mata v. Avianca was a New York case where a federal judge fined two lawyers $5,000 for submitting a brief with completely fabricated cases that was generated by ChatGPT. That was the wake-up call. And most people have heard about that case, but since then, and even into 2026, you'll see that the pattern continues. We continue to see situations where courts sanction lawyers and find issues with attorneys and other parties filing briefs and motions with hallucinations. If you look at the trajectory here from 2024, where fines were a couple $1,000s, then you get into 2025 and into 2026, much higher fines and bar referrals that were suggested. A 90-day license suspension in Colorado, where an attorney used fake citations and then lied to the judge about it. And then look at 2025, 2026, where certain attorneys were disqualified from representing clients in court. And there's an interesting case that I want to talk about. This is actually one in Nevada that's on the screen. It's a 2025 case. It's the ComNV v. Uprise case. This one's worth a moment of discussion. Two attorneys at a well-known national law firm in Nevada submitted a brief containing what the judge found to be at least 14 fictitious citations. Judge Hardy in Washoe County, he did something creative. He gave the attorneys a choice. They could pay $2,500 each in fines and face removal from the case and a bar referral, or Option B was write to your law school deans and bar officials explaining what happened and volunteer to present on AI and professional responsibility. That is a judge who understands that the problem is not just about punishment, it's about education. I'll also mention one other thing that I picked up is that the judge had also told the lawyers if you present on those topics, he volunteered to join a panel for that discussion. Now, the chart that you see here, I verified all of those cases except for, some folks may wonder, was this generated from AI? No, there's a website, and I'll give you a reference. I have the reference here in the slides, AI hallucination cases database. But I did look at all these cases except that Nevada one. There's no public order. So the information that I picked up about that case actually came from articles and news stories that were written about it. There's one more case I want to highlight before we move on. That's Johnson v. Dunn. And that's a Northern District of Alabama case where a large, well-regarded firm that had adopted an AI policy still ran into trouble, even notwithstanding having the policy, and filed a brief with fictitious cases. They weren't supposed to file that without practice group leader permission and going through proper channels in the firm. And what that tells us is this is not just a situation where having a policy in place is going to be enough. If you're a partner, if you're a founder, supervise others at your law firm, you need to have a policy. You need to enforce it. You need to have some guardrails in place, checklists, and understand what the rules are and understand what your responsibilities are as an attorney. All right, we're going to move on. Oop. Talk about our next section. A little bit of background before we get into the rules. I want to make sure that you all understand the difference between generative AI and agentic AI because there's a distinction and it matters, and no one's really talking about it much yet. Most of what you hear about right now, the ethics opinions and the cases that we talk about, involve generative AI. These are tools like Claude, ChatGPT, Copilot, CoCounsel, and Westlaw, where you give a prompt and they generate a response, and that response is predictive. It's not a reasoned response like an attorney would give. The analogy that I've heard that works really well, it's like a overconfident, super smart uh, intern or junior associate that's subject to make a lot of mistakes because they don't have the rationale and the reasoning down. But what AI does is actually act on a predictive model based on a series of words and codes and predicts what should come next. And that's how you get these hallucinations. Uh, the generative AI is what you see on the left side of the screen. And where things are going is to agentic AI. And if anybody has used some of these systems, these are interesting because they don't just respond to a single prompt. You give them an objective and they figure out the steps to accomplish it. They might search multiple databases, synthesize your results, draft memos, revise the memos, and deliver a finished product. The attorney might only see the final output, and you may not know what the system did in between to generate that output. An analogy would be hiring somebody in your office and having that person maybe go pull cases and ask them to research a specific issue and come back to you versus having somebody in your office and giving them assignment where they file something in court and they've gone through all the steps to get there. And again, if you're supervising that, you need to understand that you're responsible. The right side, the agentic AI, this matters for our ethics discussion because the supervision looks very different when you're reviewing a single AI generated draft versus where an AI system has executed a chain of 10 or 15 decisions to get to that draft. Competence is harder to satisfy when you can't see the immediate steps. Confidentiality risks compound when the system's pulling data from multiple sources and sending it to multiple places, and you lose some degree of control that you give up to this device or to this agent. As to the communication question, what you tell the client, this gets harder when you don't understand specifically what the AI did. The current ethics guidance that we see so far does not distinguish, that I've seen, between generative AI and agentic AI, between these categories. The tools are evolving, but the guidance that we're getting from courts and from legal authority is not keeping pace. All right, moving into the regulatory landscape. Let me quickly orient you to the sources of authority that we're talking about today. Um, we look to the ABA model rules, and there's a specific key development there with formal opinion 512. It was issued in 2024, July of 2024, and this is the ABA's first formal ethics guidance, specifically addressing generative AI. And it covers six model rules and concludes with a line I think should be ingrained into your memory. A lawyer may use generative AI only to the extent that the lawyer can reasonably guarantee compliance with the lawyer's ethical obligations. This is a high bar. You have to reasonably guarantee compliance. Again, the responsibility is on the attorney. The ABA Task Force on Law and AI has also issued two reports in 2024 and 2025. The year two report from December of 25 is significant because it concludes that AI has moved from experiment to infrastructure. And it signals that the profession is no longer debating whether it'll be adopted. It's now talking about how to bring it into our system responsibly. In Florida, we have Ethics Opinion 24-1, which was approved unanimously by the Board of Governors in January of 2024. And in that opinion, essentially what it stands for is that lawyers may use generative AI but must protect client confidentiality, verify all outputs, avoid improper billing, and also must make sure that chatbots identify themselves as non-human. So if you're using those for marketing purpose or if you have them on your website, you need to make sure that you're identifying those chatbots as non-human communicators. The Florida Supreme Court has also amended Rules 4-1.1 and 4-5.3 to explicitly reference generative AI. And this makes Florida one of the first states to put AI-specific language into the rules. Florida also, you should be aware, has mandated a 3-hour CLE requirement per cycle on technology. So you have to do a technology CLE. If you're attending today, this may satisfy your technology CLE requirement. Make sure you file your necessary paperwork. I am going to apply for a credit approval, but you could get technology credit and or ethics credit for today's presentation. Nevada has not issued a formal ethics opinion yet, but the State Bar Advisory Group has been formed. And what makes Nevada interesting is that under its rules, Nevada looks to the ABA where its own rules don't speak to a specific topic. So the comments and the guidance from the ABA is binding in Nevada, including Opinion 512 that we talked about earlier. Uh, and The Nevada courts are already starting to enforce standards under that revised rule, and we'll talk in a little bit about what some of the individual courts are doing as well to deal with AI. I'll just make a quick note. I touch on these specific rules. One, it makes an interesting comparison and contrast. Two, it's sort of out of my own self. It's a little bit of selfishness because I'm licensed in Florida and I'm licensed in Nevada. So it gives me an opportunity to talk about the rules, learn about the rules at the same time, and give you an update and compare how the states are doing it differently. All right, moving on, we're going to dive into what hasn't really changed except for the way that we're adopting to the new technology, the 5 core duties. And this is the heart of the presentation. The 5 duties that every attorney has, and it's applied to artificial intelligence. Here you see on the screen the ABA model rule, the Florida rule, and the Nevada rule of professional conduct for each. And I'm not going to read through the table. You have it in your handouts or in the materials. And what I want to do is go through these individually and give you some practical takeaways. All right. We have competence under Rule 1.1. And since 2012, Comment 8 has said that you need to understand the benefits and risks of relevant technology. Florida's comment now specifically says that it refers to generative artificial intelligence. And so this isn't optional. If you're using AI in your practice, which you probably are, you need to understand what it does, what it doesn't do, and where it tends to fail. One of the most important points from the ABA Opinion 512 is the level of verification you need to perform depends on the task. using AI to brainstorm arguments, that may require less verification. If you are using it to draft a brief with specific citations, you need to independently go out and verify each citation to make sure that it says what the brief says that it says. Make sure that it's valid and make sure that it supports your point of law. By the way, this isn't much different than what we would do as young attorneys, 20 years ago. In one of the first big cases that I ever worked on with Sam Lionel, a legend out in Nevada, Sam and I were working a case together and filed a motion in federal court, and he gave me the motion to dismiss that I had done some research, he had drafted and asked me to do some site checks for it. Uh, I didn't do exactly what he wanted, and he was very upset. Before we filed that brief, that went through several sets of revisions and eyes just to make sure that and I learned a lot from Sam. It was a good experience. Just to make sure that the material was perfect when it got to court, we both were reviewing the sites to make sure that everything was dead on. Here's a forward-looking point. With agentic AI, competence gets harder. If you're using a system that makes its own intermediate decisions and you see only the final product, how are you going to satisfy your duty of competence? You need to understand what happened between the prompt and the output. And if you can't, you may not be using that tool for the specific task that you are dealing with. Pardon me here while I orient my slides a little bit. All right, communication with clients, communication in general. This is one that generates some anxiety with lawyers that I've spoken to. Do I have to tell my client that I'm using AI? And I was thinking about this as I was putting these materials together. And I think it depends in part on how you are using it. And the analogy I came up with myself is that nobody discloses to clients that you're using Westlaw instead of going to the law library to do research. And Westlaw or Lexis, I'm sure, has the same thing, has built in AI tools into the search databases. The Westlaw that we use today is dramatically different than the Boolean search Westlaw that I used in law school back in the late 90s and early 2000s. Uh, Nobody discloses to the client that they're using spell check to check a brief, or that they're using document comparison software to figure out how version one changed from version two. So I look at AI and much the same way that it falls on a spectrum of how you're using it. And I break it into three categories I think is useful. If you're using AI as a research and brainstorming tool to come up with ideas, you're not putting any client data into it. You're just trying to maybe create arguments, and you're using it for to be a better lawyer, much how you might use a colleague in the office. That's I would say on the far left side of the card that you see on the screen, where it's just brainstorming and probably less duty to disclose specifically, have that disclosed to the client. If you're using it as a drafting tool, especially if you're inputting client-specific information into a third-party platform, that falls in the middle. This is closer to hiring an outside contractor, someone who touches client files. We've done that. Anybody who's ever worked on a case with lots of documents and you bring in uh, a third-party contractor to handle the documents and use some of the document software that we used 5 years ago, very similar to that system. And in those parties, you have to make sure that they're bound by rules of confidentiality. You have to make sure that you vet the platform, that it keeps everything confidential, and you want to disclose to your client that you're bringing in this third party who's going to have access potentially to confidential information and what duties, what you're doing to make sure they're protected. The disclosure obligation here is really about protecting confidentiality under 1.6. It's not the fact that you're using the tool. The third category, which is on the far right here, is the client-facing AI. Chatbots on your website do an intake. Again, Florida Opinion 24.1 is clear about this, that prospective clients and your existing clients must know they're communicating with AI, not a lawyer, and a chatbot must have appropriate disclaimers. All right, reasonable fees. Oh, there we go. Reasonable fees. This is where we want to shift the conversation a bit. Most CLE presentations and the stuff that I've reviewed preparing for today, simply, and this is sort of what the Florida opinion says, is you can't, of course, we've always had a rule for attorneys that you can't bill unreasonably for your time, and you must have an agreement that the client understands how you're billing. You can't bill a full hour for AI for work that AI completed in minutes. So your initial drafting, you're outlining things that you may have done, document review that may have taken you hours in the past. It's now much more efficient. You can't bill for that time anymore. Especially if you're charging by the hour. Now there's alternatives. Maybe you're doing contingent fee work, and it's certainly going to be helpful. Maybe you're doing flat fee work. Again, this is going to make you more efficient. But this isn't much different than what we've always done. Again, when document review, the technology started to develop when we got into the electronic stored records and ESI and discovery. The way we did discovery changed because the tools were much more efficient. And what you were billing for was really the contractor and your ability to use these tools and review the documents, different than when you picked up a big file of documents and had to go through them by hand. Uh, Not billing for it is technically correct, but I don't think that that's exactly the way to look at it. Uh, what I see with AI is that it shifts the work. It doesn't eliminate it. AI may give you an initial draft of a motion in minutes that may have taken you hours previously, but you still have to spend the time crafting the right prompts, reviewing all the citations, again, making sure that the citations are accurate and support the arguments that you've made. You maybe had to review some of the legal authority, or probably should have reviewed the legal authority in advance so you know what citations you're going to be relying upon. Uh, you have time making sure that the analysis applies to the specific facts of your situation, revising the document. Very rarely does AI produce something that I've seen that's ready to go on the first batch. There's still revisions that have to go in. The attorney's judgment, your professional judgment analysis, is still required. It's still real, and this is still billable attorney work. Verification alone is substantive legal analysis. It's not a clerical review. And this is what nobody really talks about. The time that AI frees up from the mundane tasks of document review or typing out the motion or doing the initial research, this is now time that the attorney can spend on strategy, creative problem solving, and the thing that clients actually value most, which provides for better representation. It's a value proposition, not a billing problem. And I want folks looking at this to start thinking of it that way. One of the things that I complain about most. I love my law practice. I have great clients. But one of the things over the years is as we've gotten busier, and certainly for me, I'll speak to myself, as I've gotten busier as an attorney, clients expect rapid fire work. And thankfully we're busy in the firm. I'm busy in my practice and have been for years. But clients expect quick turnaround, and they expect when you have the experience that you're going to be able to give them the answer and fire something back. Right now, I'm working with a client who's trying to negotiate the sale of a business, and it's a big deal. It's life-changing for him, but there's a bunch of moving pieces, and there's other investors and other components to think about. And sometimes we get information or we get a problem, and what I lament is that we don't often have time to really think about it, to think about the strategy. Think about lawyers who go to court. If you are gearing up for trial, you're expected to maybe draft motions and jury instructions and prepare all your examinations. But how much can you really tell a client? Like, I spent thinking about this. Clients just want you to keep producing stuff, right? I think the attorneys feel an obligation to do that. We really have an opportunity here to free ourselves up to make this more about providing better representation for the clients by thinking through and really strategizing on the stuff that's most important that requires the attorney's expertise that the AI is far from being able to replace. So think about it that way. All right, enough on the fees. We're going to move forward. All right, here's a couple scenarios I want to give you, and I don't have clean answers for these, by the way. These are questions. I think they're tough ethical questions, but you're going to see a pattern here, and these are things that haven't changed over time. So look at scenario one. You spend 8 hours researching, let's say, a non-compete issue for client A. And I just did this recently, and I had to deal with the question of competition by proxy and conspiracy, and if a third party that's not bound by an agreement competes. So let's say you have a similar situation. You research this for a client, you deliver a thorough memo to the client, and it takes you maybe 8 hours to produce that work. Then a couple weeks later, next client walks in with the exact same issue. You already know the answer. and you just looked at it, maybe you have to go back and make sure the research is still valid, but not much has changed in the last few weeks. How and what do you bill the second client? If you spent 8 hours on the first client, you billed the client for that 8 hours and it was fairly billed and it was time that you spent, do you bill client B for the same amount of time? Or do you do what I've done many times over the course of my own legal practice is think that I spent too much time looking on an issue, but I really wanted to be thorough for a client. So even though I spent 8 hours on it, I only billed the client four because I didn't want the client to have to pay for all that time while I learned about a new issue. So if I build the client four, again, how do I build a second client when I've already done the work and it may only take me an hour or two? Well, now we just take that one step further. Let's say it's an 8 hour issue, but AI helped you do the research in 3 hours. And you went through and you verified all the material. And now you get the client B, and maybe it only takes 45 minutes because you can do it much quicker. Has anything changed ethically? Or has AI just simply compressed the dynamic that we already had and already had to deal with? And and experienced lawyers have always benefited from accumulated knowledge. And you have to figure out how you fairly get compensated for that, for the time and the energy and the effort that you put in. The attorney who's handled a couple hundred employment cases, like my friend John Finnegan, or someone who does that type of work, they can probably draft a separation agreement in under an hour. So do we require John to bill that similar to a junior person, or do we require them to knock off time or do it in a different way? Or do you pay for those years of experience? Maybe you pay for it again through a flat fee, through a higher hourly rate. Now, let's take a second scenario. You invest in an expensive AI platform. You become significantly more efficient, your firm's more efficient, and your hourly clients need fewer hours. Your revenue drops. Did the ethics rules just penalize you for being a better lawyer? Or is this a time that maybe we need to stop as lawyers and rethink our fee structure? And anybody who's ever dealt with clients, and this is going to happen more and more, clients or adverse parties who are using ChatGPT seems to be the favorite. And chat will continue to take you in circles and tell you what you want to hear and bring, and chat will, you'll never be done with chat. I've dealt with that with clients and with opposing parties. Uh, is anybody, a lawyer who's skilled and knowledgeable in an area, ever given a question to ChatGPT and it gives you an answer that you're satisfied with? Typically, what I found is it's helpful. It's helpful for brainstorming, but no, and I don't use chat. I use other sources that I think that are much better. Anyway, let's move on. So now let's go to the third scenario I have here is you have a subscription, an AI subscription. You pay hundreds of dollars or maybe thousands of dollars a month. Is that overhead? Or is that is it like Westlaw? And then people sometimes will use Westlaw for specific clients and then pass that charge on because they're able to do it by the client. Do you do the same thing with your AI tools, or is this overhead? How do you compensate? If you get a tool that makes you more effective because it's an AI tool, you've lowered your hours, and now you've got this additional expense. It's probably improved your skill set if you're doing it properly and you're giving better representation. Should you be penalized for that? And so I'm not going to sit here and give you the same AI uh, ethics trope that you hear in these seminars that tells you, well, you can't bill unfairly, you can't bill for that time. No, lawyers need to rethink how we're doing the practice, or nobody's going to want to do it. Because as much as I love doing a lot of what we do, I don't want to do it for free. Next slide. Confidentiality. This is a duty that carries probably the most risk right now. The core issue is simple. And when you put information into a client information into a third party AI tool, where does the data go? Who stores it? Who trains on it? Can it show up in someone else's output? You need to know this. Again, not much different though than when people were moving, law firms were moving from the being sold the hard drive that you had to keep in the office and pay somebody to maintain and have security attached to it. To when people started putting their information in the cloud, whether you're on Microsoft's Azure, a SharePoint platform, or some other cloud-based platform, security was always a concern. Security is a concern in healthcare as well with HIPAA. So it hasn't really changed much. You just need to understand now that with the AI tools, if you're using these tools, know whether or not that data gets shared. Your lawyers, read the privacy policy, read the terms and conditions, read about what happens to this information and figure out if this is a tool that you can trust. If you don't, you have a potential confidentiality breach. Florida Opinion 24-1 is very specific and practical about this. You need to research the provider's data retention and sharing policy and make sure they're contractually bound to keep the confidentiality. If that's a tool that you're going to use and input client information. This is also an area probably where you should be disclosing to your client that you're using these tools so they're aware of it. And I suggest maybe you put that into the into your engagement that you'll use these types of tools. Supervision of non-lawyers. This is Rule 5.3. This is interesting because the title changed from non-lawyer assistants, assistant plural, in 2012, now to non-lawyer assistants. And so that was an intentional change designed to capture technology services. And in 2024, the Florida comment update makes it explicit that lawyers should continue to consider safeguards when using assistants and technologies such as generative AI. You're the lawyer, you're the supervisor, you're the one in charge. Your name has to go on this. You cannot delegate your professional judgment. You have to review, you have to know where the information is going. You have to review the outputs. And ultimately, if you're sending stuff to a client or you're sending stuff to a court, you're going to have to sign off on it. The question gets a little bit harder when we talk about agentic AI. Are you able to verify all the steps? Certainly, you need to know what the agent is doing. By the way, there's all different types of agents. Before you start using these, there's already some, anybody's heard of, there's OpenClaw and some other tools. Be very careful about the information. There's some nightmare stories already about people giving the agent carte blanche access to its records on the computer, and then the agent runs off and does a bunch of stuff that they weren't supposed to do. If you wouldn't give a new legal assistant your email password and authority to go into your Outlook or whatever you use for email and send messages to clients, do not do that with an agentic AI. Make sure you have a control mechanism. Personally, I've started using agentic AI outside of law. I'm using it on a totally separate project. I wrote a book on negotiation and mediation, and I have my mediation practice. And I used an agentic AI to build a website for that practice. If you want to check it out and see what an agent can do, you can go to recomethod.com, recomethod.com. I developed that entire website using an AI agent. I gave it its own email address, set up a separate account for it, and whenever there were specific requirements to log in and out of accounts for it to get information, such as attaching the domain name to the website, I did that myself. I had the agent stop, come get me, just like you would have an assistant. Hey, if you're about to log into our bank account or you're about to log into confidential platform, come get me in and I'll log in. I'll put my credentials in. I'm not going to give them to you. All right, candor to the tribunal. We're starting to see some more developments here. Rules 3.1 and 3.3 say that you shouldn't assert frivolous positions and and false statements of fact are also prohibited when presenting information to a tribunal. This is the area where the sanctions cases live. Fabricated citations are a direct violation of this rule. And again, if you go to that website that I put earlier, I think it's in the materials at the end, you'll see it's just there's constantly new cases coming out into 2026 about the hallucinogenic AI. People are still dealing with this issue. I want to talk about a couple emerging issues here. In first, Noland v. Land of the Free that you see on the screen. This is a California case in 2025. The court sanctioned the attorney who filed fabricated um, citations, but it declined to award fees to the opposing counsel. Why? I think it's because I didn't read the entire opinion, but I think it's because the opposing counsel, it seems like the court caught the issue. The opposing counsel did not catch it and alert the court. So think about that, what that implies. Someone else on the other side filed a motion, and neither of the attorneys involved in a case seems to have caught that. And that begs the question of whether we're moving towards a a world where you have a duty not only to verify your own citations, but to verify the other side's. By the way, most good lawyers have been doing that for years. This isn't a new issue. And every once in a while, when you have that issue, if you're a litigator, as I used to be, I like to say used to be, if somebody cites a case and either the citation is wrong or even better, because sometimes the citation is just a typo, if the case does not support that proposition, you need to call that out. We have the same thing going on here. So especially with AI, maybe people are citing cases that don't work. Second, Johnson v. Dunn, there the court observed that the current rules may not adequately address careless AI use, such as making a knowing representation, and Rule 11 does not cover these discovery disputes. Candor obligations generally require knowledge of falsity, so there's a gap between what the court rules are doing and what they're going to have to address. All right. Courts are getting more active at a local level, and we'll talk about what they're doing. My own home court here, the 18th Circuit, um, and some other courts. There's three so far that I found. 18th Circuit here in Seminole and Brevard County, the 11th Circuit, and Miami-Dade, the 17th Circuit, have issued orders that require attorneys to disclose if they're using generative AI in their production and verify that the information is true and correct and they take responsibility for it. Again, I think when you file something, I think it's a good reminder, and I don't knock Judge Chase in Seminole County or any other judges for entering these orders. I think it's very valuable, by the way, for pro se parties and people from out of town because more and more pro ses are using this material. But when you sign this as an attorney, if the rules really changed in 20 years, when you sign something and file it, you're responsible for it. There's certification language that I want to show you here from or read to you that yeah, I did. I put the certification language here on the slide. Generative artificial intelligence was used in the preparation of this filing. The undersigned certifies that all factual assertions, legal authority, and citations have been independently reviewed, verified for accuracy, and accepts full responsibility for the contents of this file. Again, the responsibility isn't much different than what we've always had the obligation to do as lawyers. I want to touch on a case study, and gosh, I've got a little bit of time. I'm good. Um, we do have a question. All right, I love questions. Let me jump in here. I got to move around my screens. All right. So I've got a question here. I'll read it out. If I revise a client's employment agreement that will be seen by hundreds of people and is not subject to a confidentiality provision, can I upload it in Copilot for review without redaction? Uh, that's a great question. Uh, the I have done some other ethics seminars, and the bar sometimes takes an interesting view of what you can do, even though information becomes public, particularly with respect to law firm reviews. But I don't want to go too far off tangent. I have recommended, what I think is good practice is if you are using these tools and you're not sure about what happens to the data that you input, you can anonymize them, right? If you're looking at a contract, you anonymize the contract, and if it's a form that gets used over and over. In this case, if you have the employment agreement, um, and it's not subject to confidentiality, you still may have personal information. I would use the standard of when you file information in court, what information has to be redacted? Does it have compensation information? Does it have that person's home address, personal contact information, any other details about that person that maybe they don't want disclosed in public? So I would still be careful. I think also if you are using Copilot, that's a Microsoft product, and look at how Copilot is treating that information. If you're using Copilot in your SharePoint platform, I know here in the firm we use SharePoint and we rely on it for security. There's a mechanism to keep information encrypted if we need to share that information and send it outside the firm. And we make sure we have a team in place. Thank you, Tony and his team that make sure that all of our security is up to date. And so I would feel very comfortable using that Copilot tool in my own environment. Would I take that contract as is if it has any potential personal information and upload it into a public chat GPT? No, I wouldn't. But I think it's easy enough to redact that information and then just take your anonymized document and put it to chat as long as it's just general information and it's not something that would be considered confidential. If it's something that's going to be filed in a court file and it's a public filing, again, it's going to be available. It's going to be a public record. The confidentiality rules are different. So that's a great question. I think it depends specifically on what information might still be considered personal in the document and what platform you're using. I hope that's good. Thank you for the question and welcome any other ones you may have. All right. This is a case study that I want to talk about briefly here, and these are from my own personal experience. It doesn't involve lawyers. One involves a lawyer, and one involves legal citations that looked authoritative but weren't. So I have in these case studies, by the way, I have anonymized the information, but the facts I'm going to give you are very real. We'll take the first case. Case A healthcare provider that I've represented for some time was facing a healthcare recoupment claim of over $800,000 under a federal payer program administered through a third-party administrator, what we'll call a TPA. It's just a commercial insurance company that was administering this federal payer program. And they had notified me of this last year that they had gotten an audit letter. And I told them get it over to me because these things have certain time frames that you have to respond. I've done a lot of audit and recoupment claims with healthcare clients over the years. I have another one that's been going on for 3 years dealing with Medicare. It's almost $1 million. It's actually over $1 million with interest. These are things that, if they're not handled properly, can be disastrous. So I said, hey, send it over to me. Let's take a look at it. She decided not to do that, and I think she sent back a letter and submitted a response to a recoupment claim. Recoupment is they've audited your records, and now that administrator or the payer is saying, we looked at your records. We don't believe that usually what they'll say is either the records don't support the claims, and so you don't get paid, or you have to give us the money back, or these services that you provided were not medically necessary. They'll come up with some argument, but most of the time when they do an audit, they come back and they send you a letter that says all your claims are bad, so you have to give us back all the money. In this case, it was a little over $800,000 at stake. So the provider sent a response back. And this was late last year. I think it was November, December. They sent a response. They went back and forth a couple times with the TPA. And finally, they were getting no traction. And when I talked to them, they said the administrators ignoring us. They're acting like we didn't respond. I said, well, send it over to me. This is right before I left on spring break, mid-March. And I looked at the response and I thought, well, this looks pretty good. And some of these arguments I wasn't even aware of. And I spent a couple hours looking at the response, trying to get my arms around what was going on generally. And then I started looking at the CFR, the Code of Federal Regulations that was cited in the response. And here's the problem. The regulations they cited had nothing to do with the provider recoupment. The authorities they relied upon were things like fair housing laws and protection of veterans' benefits against garnishment and wage garnishment and attachment. Totally unrelated authority from the federal regulations. Real CFRs, but it did not support the issue that they needed support for. So the response looked good, and it was polished, and it looked very aggressive. And if the supporting authority was good, it would have maybe been very effective. But my view is that the administrator ignored the response and treated it as gibberish. They treated it as though there was no substantive response filed at all. They were ignoring it, and they proceeded into the recoupment phase. And once that happens, you may be past certain deadlines. You need to act fast. There's steps involved in the process, but now they were recouping. And when they recoup, they tell you have to pay us back all this money. And if you don't pay us back the money, we're going to offset that against your future claims. So now the provider is working essentially for free. By the way, I have absolutely no doubt this provider and the relationship I've had with the provider that the claims were good, genuine, and payable. It's just a matter of making the administrator understand that they were payable. All right, so that's case one, real story. As it happens, I come back from spring break and got some very good news in a case I was dealing with another client. I represent this another healthcare provider, and we're going through and have been since 2023 a Medicare audit where Medicare's administrator had alleged fraud. It's a UPIC audit if anybody's in that world, and they made a recoupment demand of $913,673 plus interest. And I've represented that provider for the last couple of years. We've gone through all the steps, and the Medicare appeal is a 5-level appeal that goes all the way to the district court. There's redetermination, reconsideration, and then you have the ALJ, administrative law judge hearing. We went to an ALJ hearing. The ALJ ruled favorably. It went up to the Medicare Appeals Council. Medicare Appeals sent it back to a second ALJ, and the second ALJ agreed with our position, wrote a very grounded position. They had an 80-page opinion fully supporting the payment of the claims. It was fully favorable for our client. And that came in. We got that. It was dated March 25th, and I got it just maybe about 2 weeks ago. So, there's an interesting compare contrast between two very similar claims, one relying on AI and one not. First, authority versus the appearance of authority. In case A, the citations look good. The authority did not apply. In the second case, the real one that I handled, the authorities were ones that directly govern the dispute. AI can generate authority, it can't confirm the authority applies. Two, speed versus survivability. The first case was fast, it was front loaded, but it collapsed under pressure. The second case was slow, iterative, took several years, and it shows that the test isn't how fast you move, it's whether or not these arguments can survive scrutiny. Three, confidence versus competence. Again, AI is like the overconfident, super intelligent intern, you've got to check the work. It sometimes will produce great stuff or great sounding stuff. Another analogy that I heard I really liked was think of like navigation. You wouldn't use a navigation device in your car and go to sleep, or use a navigation device and not look out the window. Even though what the instructions you are being given sound authoritative, you always want to personally verify them. And how long have we had navigation? 20 years. We've had navigation devices. You still look around and make sure you're going the right way. Four, process alignment. The first case, the arguments were not aligned with the payment contract, the payer process, the governing framework for the appeals, and the arguments in case B were aligned with the Medicare appeal structure and the evidentiary standards and the expectations from the ALJ. And attorneys that have experience know this, that winning requires alignment with the system, with the procedures, and with the facts of your specific case to make the most persuasive argument. Finally, five, ethical responsibility. In both cases, it's the professional who signs the work who's responsible for it. Thankfully, my name wasn't on the first case. There was no attorney that was on the first case that I understand. But this is an example of what can happen when you over rely on the tool without verifying the applicability. All right, I'm going to give you a practical toolkit, some practical takeaways for today. These are discussed. I think you'll have a handout where these are discussed in more detail. And again, I welcome any questions on this during the presentation or after. I think this is a fascinating topic, and it's probably one that's going to stick around for a while. I'll keep this material going and continue to update it. There's actually some cool tools. I wrote one down I just came across, and this isn't in your materials, but maybe we can send this out afterwards. Responsible AI in legal. Oh, I had the website up. I was looking at it. Responsible AI, it's Rails, Rails, Responsible AI in legal services. There's a whole website that keeps an update of authority, ethical authority, orders from courts around the country, and it continues to update it. It takes inputs from individuals, so you can go there, sign up to get updates. Rails, Responsible AI in legal services. Pretty good website. All right, for folks today, what can you do? Update your engagement letters. Add a technology provision that addresses AI assisted services. You don't need to have a client by client consent for using AI for research, where probably a lot of folks are using it, but make sure you have this, at least have it in your engagement so the client knows that you're using the most modern tools to provide the best services possible. Second, develop an AI use policy in your firm. Acceptable use, verification steps, what processes do you go through, supervision protocols. Not only develop the process, make sure when you develop the process, you're following the process. Don't get overcomplicated here. We're not talking about pages and pages of a book that nobody's going to understand. Just simple steps. If we're using AI, we need to know what tools we're using, Ensure the confidentiality, the security of the platform, know what happens to the client data, and if it's spitting something out that we're going to look at, who's looking at it. I like to have a policy generally that says two sets of eyes, of human eyes, look at everything before it goes out. I think that's a good policy to adopt even when you're using AI. Third, build a verification checklist. Every citation, make sure they exist, make sure the case says what it claims to say. This is not going to change for a long time. Our job as attorneys is getting more efficient. In some respects, the mundane part's going away. The stuff you got to think about and the stuff where your tail is on the line, that's where you need to be focusing your time. Fourth, think about your billing model. If hourly billing creates uncomfortable incentives around AI efficiency, consider flat fees. I remember 10 years ago coming across a law firm, and I know a lawyer, like Dan Marchese up in New Jersey. I've worked with a few times. He's a New York attorney. We've co-counseled cases. Uh, Dan does a lot of work, like trial work and appeal work on a flat fee. I never understood how he could do it on a flat fee. He loves doing trials. He takes these commercial cases on a flat fee. I couldn't quite figure it out. But with AI, now knowing that you're not going to be stuck in a morass of document review, maybe a flat fee model is better. Maybe something that's more results oriented, something that works that's fair for you and fair for the client. Of course, the contingent fee lawyers already know this, and they have their own system. Um, Fifth, again, I've mentioned this again and again, before you use any AI tool, then you're going to input client information. Make sure that you understand the confidentiality protections and the security of the environment. All right, we got time to talk about a couple other interesting here, some emerging issues. And these aren't taken from anywhere. This is sort of me thinking out loud as I was putting this together. Um, and I think could eventually be one of the most important parts of the presentation. Right now, the conversation we're having about is the risks of using AI. We've discussed sanctions and disclosure orders and the rules and what happens when you use it poorly and irresponsibly. The responsibility is on the human, it's on the lawyer, especially the partner in charge. I think a paradigm shift is on its way, and it's going to be here before we know it. Uh, Let me go to the next slide. Right now, you can be considered negligent or in violation of the rules. You could get yourself in trouble for not using AI or not using it properly. But eventually, we're going to get to a point where the AI is so good that there may be some claim of negligence for failing to use it, specifically where the AI can improve the research quality, catch errors, and improve human performance. We're going to look at this in a sense where think of a deposition where you're asking somebody, you rely on this third-party tool to get the information. At some point, we're going to expect that you do use these third-party tools to make you a better lawyer. AI as expert authority. Another question that'll be debated, and again, this is on the heels of having just gone through a presentation similar to this with my healthcare provider folks, audience. More and more, we're seeing AI support the healthcare industry in evaluating blood work and screenings and tests and x-rays and MRIs. Right now, all the factual opinions in litigation require a human certified expert. The physician certifies the medical opinion. An engineer certifies structural analysis. In a few years, what happens when the AI can outperform these individuals? Think about a diagnostic AI that catches a pattern in radiology images that the human radiologist missed, or AI that analyzes thousands of billing records and finds statistical anomalies, which, by the way, I think they're already using to audit my healthcare clients. But things that could be done in on the push of a button that were taking months for human auditors to catch. The expert might still sign the report, but the analysis behind it is going to be more and more AI driven. So the question is going to be, what level, how does your expert relate to the AI? Where is the balance where the expert's relying on the AI to certifying that the AI is correct rather than the AI supported the expert opinion that's correct? I think that the AI as an expert is a question that's coming. We saw a few years ago, by the way, this started me getting involved with some other material with the ABA, we saw the AI as a witness when the famous Amazon case from 5, 6 years ago. I wrote an article about this for the ABA on an Alabama case where subpoena records or records were subpoenaed from Amazon to get statements that were made into an Alexa device to determine whether or not any background noise or any information supported a murder charge against an individual. Now we're going to have the AI as the expert. All right, and then we've got stuff we won't have time to touch on today, AI generated evidence and deepfakes, but know that there are some proposed rules at the federal court level that I've seen where we're going to see some rulemaking come out of the federal court addressing AI generated evidence. And finally, I mentioned this earlier, and it's beyond the scope of today's presentation, but if you're using chatbots in your advertising or in client communications, it needs to be clearly disclosed to the client that you are using these tools. Finally, in closing, uh, AI is coming to every profession. It's not a question of whether to adopt it, it's how to integrate it responsibly, working with the AI, with each other, and working to deliver the best possible service to our clients, to our patients, and to the public. And the attorneys who figure this out are going to thrive using AI because it's going to make them better at what they're already good at doing. They're already good at judgment and combining legal authority with good judgment. Uh, and the folks who continue to do that as they adopt AI will find this will enhance their practice for themselves and for their clients. I had a lot of fun putting this presentation together today. I did use AI to help me organize the material, but I did read the materials that we referred to. I have those sources if anybody's interested in that. Somebody's asked a question, how you can receive certification of attendance. Yeah, we'll send that an email. We responded. If you have any other questions, I could field those, I think, for another 2 minutes. Happy to take further questions or ideas how to make this presentation better or enhance it, give you better information. If you are licensed in Florida, make sure you apply for your CLE credit. If you need any help with that, contact my office. And same thing in Nevada, apply for CLE credit. I will certainly be doing that. My contact information, there on the screen, and feel free to shoot me an email if you want to talk anything about AI, ethics, law, or negotiation or mediation. Check out ricomethod.com. One last plug for my website, my forthcoming book. Thank you, everybody, and have a great rest of your day.